Hello again. Welcome to the final episode of the Law in Motion saga. This is episode 6. The return of the motion. We're going to be talking about post-trial motions today. I brought a friend back here, and so hopefully you recognize him this time, for this extra special final seminar. As usual, we have the disclaimer because I'm a court employee. I'm happy to take questions, but I can't take questions about any matters that are pending in the Contra Costa County Superior Court. If any questions come up, please don't take my answers as being an indication of how any judge might rule on a particular issue. And as we have come to get used to on this series, everything that we talk about in terms of fact patterns and forms are complete fiction, coming right off the top of my head based on the Star Wars universe. We've seen the abbreviations before in the program materials, and then we've got our fact pattern. Today, we are going to also assume that Luke Skywalker has won his judgment. He was able to get the Darth Vader Revocable Trust invalidated by judgment. And we are going to talk about what happens after the court has made its decision. So the 3 motions in particular that we're going to be talking about today are motions for a new trial under CCP sections 656, etc. Motions to vacate and enter a new judgment pursuant to Code of Civil Procedure sections 663 and 663A. We'll also talk a little bit about memoranda of costs and motions to strike or tax costs under a whole bunch of different authorities that you see there on the screen. What we will not be talking about in any detail, if at all, will be a motion for reconsideration, which is also available upon the entry of a judgment following a trial on the merits. That's under CCP 1008. We talked about that in episode 3. We will not be talking about motion for relief from judgment under CCP 473B. We also talked about that in episode 3. Motion for judgment notwithstanding the verdict, or JNOV, under CCP 629. We will not be talking about that, although a lot of the principles that we'll be talking about are the same. JNOV is generally filed in connection with the jury trial. And as we all know, generally speaking, with the exception of conservatorship cases, we don't see jury trials in probate code cases at all. And we will not be talking about motion for entry of a nunc-pro-tunc judgment. Nunc-pro-tunc judgments are used to enter new judgments where there's been a clerical error in the language of the judgment, not a substantive error. So when you talk about motion for a new trial or motion to vacate, when do you use them? Certainly after a judgment or dismissal after a demur is sustained. You can use them for a judgment of dismissal, any kind of judgment of dismissal, anything that results in the entry of a final judgment. After a motion for judgment on the pleadings without leave to amend, as long as the order completely disposes of the pleading and results in a final appealable judgment. A judgment of non-suit pursuant to CCP sections 581C or 631.8 can be used, can lead to a motion for a new trial or motion to vacate judgment. Now, just a brief moment on non-suit motions. A non-suit motion is, there are 2 kinds of non-suit motions. One is an oral motion made after the plaintiff finishes his or her opening statement. And it's essentially a demur, that the opening statement, even if everything is assumed to be true, the court must enter judgment in the defendant's favor. That is one form of non-suit under CCP 581C. Under 631.8, a non-suit motion is after the plaintiff's case in chief, and it asks the court to enter judgment and find that the plaintiff's case in chief does not make a prima facie case to justify the entry of a judgment in the plaintiff's favor, and the defendant is entitled to judgment as a matter of law. A motion for a new trial can be entered after those kinds of motions. In addition, you can file a motion for a new trial or to vacate the judgment after a granting of a motion for summary judgment, or a judgment entered as a discovery sanction, either for, usually the doomsday sanction, which we talked about in episode 2. So we're going to talk basically motions for a new trial and motions to vacate judgment are based on different grounds, which we're going to talk about right now. But as you're going to see in a few moments, the procedures are nearly identical. So there are 7 grounds that are listed in CCP section 657 that authorize the court to enter an order for a new trial. The first is the irregularity of the proceedings or abuse of discretion. And what is an irregularity of the proceedings? It's actions either by the court, opposing counsel, opposing party that results in an unfair trial and a miscarriage of justice to the moving party. It could be the conduct of the trial court, the jury, counsel, or the adverse party amounting to affirmative misconduct could justify the granting of a motion for a new trial. Now, in filing a motion for a new trial, the motion must be made upon affidavits. That means you must supply your own evidence separate and apart from what was seen at the trial or admitted into evidence at trial in order to convince the court that a new trial must take place. So, for example, if you end up after trial learning that somebody used the Jedi mind trick on the trier of fact, then that might rise to the level of misconduct sufficient to justify the court entering an order and requiring a new trial on the merits. Next ground is jury misconduct. Again, we don't see juries often, but it's worth mentioning it as a ground for a new trial. That must be made by affidavit pursuant to CCP section 658. One method of jury misconduct is the concealment of bias during the voir dire process, prejudicial communication by or to a juror. For example, you come to learn that one of the parties spoke to a juror outside of court and before the matter was submitted for decision. Another ground might be a chance verdict. For example, the rolling of a chance cube in order to determine who wins. That would be jury misconduct. On that last ground, you might, what you expect is for the jury to take its job seriously and not just leave it to chance who is the winner. Third ground is accident or surprise, which ordinary prudence would not have guarded against. This must also be shown by separate affidavit. And so what is really important, this sounds a lot like the 473B motion for relief from a judgment. However, negligence in the filing of a motion for a new trial is absolutely not sufficient. You must have no reason to believe that the event that occurred during the trial that constituted accident or surprise, that you could not have anticipated it. It is absolutely a mandatory requirement to convince the judge that the event justifying a new trial was unanticipated and could not have been avoided. Next ground is newly discovered and material evidence that could not with reasonable diligence have been discovered and produced at trial. Now, you've got there's a lot to unpack with this sentence. The first is that the evidence that you want to later present in a new trial is new evidence that has not been provided to the court during trial. It is material evidence. In other words, not only is it relevant, but it could tend to convince the court that there might need to be a new trial or even a new decision. And then could not with reasonable diligence have been discovered. In other words, it is not something, again, that you could have anticipated, that you did your diligence search, you did all of your discovery, you took all of the depositions that you felt were reasonably necessary in order to present your case for trial, and you later discovered new evidence that would have that might have made a change in the outcome of the trial. You certainly cannot present evidence that is cumulative. In other words, if it's similar evidence, perhaps by a different witness, that is cumulative evidence that would not justify an order for a new trial. Again, what you need to show is that if the evidence were presented, a different result at trial is not just possible, but probable. And it's a very high standard to justify the court entering an order for a new trial. And again, this must be presented by separate affidavit. One thing that is important is that this does not include discovery responses. In other words, where the responding party refused to respond to a discovery device, but you did not seek an order to compel. This is not newly discovered evidence. It is evidence that you should have, with reasonable diligence, have sought to compel. The next ground would be excessive or inadequate damages. The ground here requires the court to re-examine the entire record and only the trial record, and that the trier of fact clearly should have reached a different decision. Unlike the other grounds that we've already discussed, this ground is established solely from the minutes of the court. In other words, only from the record that was received at trial during the trial. No extrinsic evidence is allowed in order to justify an order for a new trial on this ground. The next ground is insufficient evidence to justify the decision. This sounds, it's pretty intuitive inquiry. Similar to the last ground, after examining the entire record, the trier of fact clearly should have reached a different decision. Again, just like the last ground, it is established by the minutes of the court. The decision is against law is the next ground. This is the failure to find on a material issue. So for example, if the court made no finding on an element, for example, of financial elder abuse to justify the granting or justify the entering of a judgment finding financial elder abuse, that is one example that could be used. Another ground would be that the findings of fact by the court are irreconcilable. That, for example, in a financial elder abuse case, that the defendant took property, but then later makes a finding that the defendant did not take property. That would be an irreconcilable conflict within the document, within either the statement of decision or the judgment. The evidence is insufficient in law and without conflict. In other words, that the prevailing party on the judgment did not make a prima facie case in order to justify the judgment, or was not able, or the defendant was not able to raise a sufficient defense to the claim. An insufficient statement of decision would justify a new trial. I've given you citation for that. Again, we've talked about before the last episode about a statement of decision and the requirements of a statement of decision that that the court must give its reasons for making the decision. But if the statement of decision fails to do that, you can file a motion for a new trial on that basis. And again, this motion is made on the court's minutes, not with separate declarations. The next is error in law. Now, this is where you try and convince your trial judge that she was wrong. You can imagine what kind of an uphill battle that would be. And in fact, hopefully, when you criticize a judge that they were wrong, you don't get the following reaction.
They're giving you clairvoyance enough to find the rebels hidden truth. I find your lack of faith disturbing.
Now, before anybody complains, I am not implying that trial court judges are the same as Darth Vader. I'm really not. That would be wrong, and it would be career limiting, although they do wear black. So there's that. Anyway, what is an error in law? It is erroneous rulings on evidence. Again, you need to be demonstrating to the court that the erroneous ruling on the evidence is material and would have resulted in and probably would have resulted in a different outcome. An erroneous grant of non-suit. We talked about what non-suit is just a few minutes ago. That the court granted non-suit improperly and should have allowed the case to go fully through the trial process with all sides presenting cases in chief. And as with the other grounds, it is made on the court's minutes and not with any extrinsic evidence. So grounds for motions to set aside the judgment. I have your verdict, but it should say to set aside the judgment. The grounds are incorrect or erroneous legal basis for the decision, not inconsistent with or not supported by the facts, and the statement of decision must be amended or corrected. Now, this is very similar to error in law or insufficient facts to justify the decision. This is where you are not asking necessarily for the court to have an entire new trial, but that if you take everything that happened in the trial and reevaluate it, you must come to a different decision and enter judgment accordingly. And as we see here under the Gibson case, the legal conclusion that is contrary to an express statutory provision, for example, is a way to convince the court to vacate the judgment and enter a new one. Now, the motion is only granted where the substantial rights of a party are materially affected. One thing of course, the moving party must show prejudice or the failure to get a fair trial. Another thing is what's interesting about a motion to vacate a judgment is that there are situations where the court might enter a judgment that would affect the rights of a non-party participant. In other words, for example, it might require an injunction against somebody that would affect the rights of a third person. That third person, because their rights are materially affected, would have the right to file a motion to vacate the judgment and enter a new one. That is an extremely rare situation, and which is why I'm not going to discuss it in any great detail, but that is sort of a unique aspect of this kind of a motion. So the procedure is critically important for motions for a new trial or a motion to vacate judgment, because it affects so many rights going down the line up through appeal that it is absolutely critically important that if you are considering filing a motion for a new trial or a motion to vacate judgment, you follow these procedures to the letter. There is no wiggle room around getting these wrong. So the first thing that you must do in order to get a motion for a new trial or to vacate is to file a notice of intention to file. This is the only document that you need to file in order to initiate the process. Okay. Now, your notice of intention must designate the grounds for the motion. And I have here a sample notice of intention to move for a new trial, or this can also be used to vacate and enter a new and different judgment. This is as simple a document as you can make. In this particular example, we've got Ben Solo, who lost a trial, and the Darth Vader trust has been invalidated. He's moving for a new trial on 3 grounds: irregularity in the proceedings of the court that prevented Ben Solo from having a fair trial, as shown by the declarations of Darth Maul and Bib Fortuna. Very important here when you are moving for a new trial or to vacate. Just like on any other regular motion that's governed by the CCP, you need to show what documents actually support your motion. And in this case, it's slightly different because you're associating the documents with each separate ground. Okay. The second ground here is evidence is insufficient to justify the decision as shown by the minutes of the court, and that there was an error in law occurring at trial and accepted to by the moving party. So for the error in law, one thing I did not mention earlier that is important, another critical component of a motion challenging or charging that there was an error in law is that you must have objected to what happened at trial, that you tried to get the court to make a different decision, but the court chose to decide against you. That is a critical important for that ground. And again, for 2 and 3, you can see that the motion on those grounds are based by the minutes of the court. And you can see at the end that it is also based on the memorandum to be served and filed hereafter. We will talk about that in just a moment. So The timing, here's where it gets really critical. You have 4 different possible deadlines by which to file your notice of intention. Either after the decision is rendered and before the entry of judgment, or within 15 days of the date of mailing of notice of entry of judgment by the court pursuant to CCP 664.5. Remember that citation. We're going to talk about it in a moment. Incredibly, incredibly important. Within 15 days of service or a notice of entry of judgment by a party, or within 180 days after the entry of judgment. And please, 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 please note that these dates, these deadlines are not extended for service by mail pursuant to CCP 1013 or 1010.6 for service by electronic means. They expressly do not apply. So when we talk about 15 days, or we talk about 180 days, we mean 15 or 180 days. If you blow these deadlines, you are out of luck.
Really bad feeling about this.
Now we talked about CCP 664.5. We're going to talk about it. I'm going to, tangent just a little bit. CCP section 664.5 states that a party has the duty to serve notice of entry of judgment upon entry of judgment. That is what the rule says. I'm going to cite to you the Van Buren case. It is California Supreme Court. I know that frequently the court enters and serves judgments all the time. The Van Buren case is extremely important because the holding of the Van Buren case is that if the court is the one that serves the judgment and there is no notice of entry of judgment served by a party for purposes of a motion for new trial and a motion to vacate judgment, the notice of entry has not been served, with 2 very narrow exceptions. What this means is that if the court serves the judgment and there's a proof of service, unless the judgment or proof of service says it is served pursuant to court order or pursuant to CCP section 664.5, then the 15-day deadlines to file a motion for a new trial or a motion to vacate judgment do not apply. It is 180 days that would apply. Now, keep in mind, CCP 664.5 does not apply where the prevailing party is not represented. So the court could serve the order or the judgment with a notice of entry of judgment, and then the 15 days would apply. But this is incredibly important. I strongly urge you, let me go back a slide. I strongly urge you, if you have any intention of filing either one of these post-trial judgment or post-trial motions, that you become very familiar with the Van Buren case. If you are the prevailing party after trial, I strongly encourage you to take a look at the Van Buren case, and even more importantly, serve a notice of entry of judgment as a notice of entry of judgment. It will benefit your client immensely and really put the non-prevailing party at a somewhat timing disadvantage because these deadlines are very, very short. There you go. Now, the practical reality in this court, and I'm talking about Contra Costa County only, the court never includes language that said, when it serves judgments, that says it is served by pursuant to court order or is served pursuant to 664.5. It never happens, and it probably never will. Again, it is the duty of the parties to serve notice of entry. It is not the duty of the court to do it unless there's a party that's unrepresented. So again, we talk about that it's a duty for the parties to do it. What's the consequence if it's a duty? Well, the consequence is you have to deal with longer time periods for appeal, for filing a notice of intention. All of these post-trial deadlines get extended to usually 180 days. But again, if you do the notice of entry, then you take advantage of the much shorter time periods to appeal and file the motions. So again, I cannot emphasize enough, it is really, really, really important to serve notices of entry of judgment when you have a judgment that is entered, even if the court serves the judgment itself. So why is it so important? We talked about the affects a deadline to file a notice of intention. And also on the back end, the court has a jurisdictional time limit by which it must rule on a motion for a new trial or vacate the judgment. And that jurisdictional deadline is 75 days from mailing of notice of entry by the court pursuant to 664.5, or 75 days from service of the notice of entry by a party, or 75 days after the filing of the first notice of intention. Again, going back to our practical matter, in Contra Costa County, since we don't include 664.5 language in our papers, you're really dealing with the last two options, either 75 days for service of a notice of entry by a party, or 75 days after the filing of the first notice of intention. That is the deadline by which the court must make a decision on a motion for a new trial or motion to vacate judgment. If the court does not rule in that time, the motion is deemed denied without a further court order. It is incredibly important. Again, this is jurisdictional. The court has no option but to make a decision within that 75-day period. And we'll talk about how we get to that hearing in just a moment. Why else is timing so important? When you file a notice of intention, appeal deadlines are extended. So you should all know the general appellate rule under Rule of Court 8.104A. In order to perfect a notice of appeal, you have 60 days after notice of entry or a copy of the filed endorsed judgment served by the court to file your notice of appeal, 60 days after party serves a notice of entry or a copy of the filed endorsed judgment, or 180 days from judgment entry. Note, please note here, I've not mentioned CCP 664.5 at all because it doesn't apply. We're getting really into the weeds of this procedure stuff, okay? So, you know, if you think that you've had a problem at trial where you could really get some mileage out of a notice of entry, or out of a motion for a new trial and motion to vacate, you really need to pay attention to that 664.5 because it really affects timing. However, if you intend on appeal and a timely motion for a new trial or motion to vacate has been filed, the deadline to appeal the judgment becomes 30 days after the court or a party serves notice of entry of the order denying the motion, 30 days after the denial of the motion by operation of law, or 180 days after the judgment. I know this is really confusing, but if you think about the timing that the court is really focused on in these post-trial motions, to ensure that if a new trial is required, it doesn't overlap the time to appeal, it kind of makes sense. And again, it's really, really important, at least from my point of view, getting that notice of entry of judgment served sooner rather than later is really going to help you determine how the dominoes fall when it comes to post-trial motions. One other thing to note, just off the cuff here, is that for filing notices of appeal, CCP 1013 or 1010.6 regarding service by mail or electronically does not apply. Again, we're talking 30 days, 60 days without an extension for the method of service. Finally, when we come to these timing issues, the notice of intention must be filed timely in order to extend the time to appeal. So therefore, if there's a dispute over whether or not the notice of intention was timely filed, and the court does not rule on that issue until after the regular appeal period, appeal deadline expires, which often happens, you will lose the right to appeal because you have blown the deadline to file a notice of intention. So again, timing is everything when we're talking about these post-trial motions. All right, so what's next? You've timely filed your notice of intention. What's next? By operation of law, the opening points and authorities and evidence, if any, are due 10 days after filing the notice of intention. Opposing briefs and any evidence are due 10 days thereafter, and reply briefs are due 5 days thereafter. Now, the court does have the discretion to extend these deadlines for good cause, but those extensions may not exceed 10 days. But as I mentioned before, the court cannot extend the drop dead date by which the court must make its decision. It is 75 days, and that cannot nor will it change. So setting the hearing. This is an unusual process, and it kind of depends on a lot of things within the court happening correctly. Number one, the trial judge must hear the motion if the trial judge is available. If the trial judge is not available, it may be heard by another judge in the same court. Now, the court must set the hearing after the deadline to oppose the motion, which is effectively 15 days after the filing of the notice of intention. Once that happens, the clerk must notify the judge that the motion was filed and a hearing must be set. Once the hearing is set, the clerk of the court must give at least 5 days notice of the hearing. Now, a couple of interesting points. If your motion is heard by somebody other than the trial judge, the court can decide on its own whether or not to decide the motion without a hearing. It has the discretion to do that if it is heard by someone other than the trial judge. Another thing is that the court is not required to hear oral argument. It must have a hearing, but it is not required to grant oral argument pursuant to CCP 661. Now, again, as I mentioned, this requires a lot of things happening within the court staff correctly. So my recommendation is, once you have filed your notice of intention, certainly here in Contra Costa County, you should bring it to the attention of the probate examiners or to your trial judge's clerk. As it will grease the skids as much as possible so that you are ensured to get your hearing before the 75-day deadline. It is technically an improper ex parte application. However, you would want to make sure that you copy opposing counsel and any communications like that to the court. This would be a specially set hearing, and keeping in mind that 75-day deadline. I cannot imagine the court having too much of a problem being alerted to the fact that a motion for a new trial has been filed and needs to be calendared with urgency. So especially if you're going to do it through there's certainly no problem doing that through the probate examiner's office. I think that would be entirely appropriate. Ruling on motion, the court has discretion to grant a motion for a new trial or to vacate. On a motion to vacate, the court may not reopen the case and consider further evidence. The court can only rule based on the existing trial record. The court does have discretion to grant alternative relief. On a new trial motion, may change or add to the statement of decision, modify the judgment in whole or in part, or grant a new trial on less than all of the issues. So there is a lot of equitable considerations that the court can make within its discretion. The order granting a new trial vacates the judgment and returns to the case to its exact state immediately before the trial. You start over. An order granting a new trial must also state the grounds for granting. The order must also specify the reasons for granting. Now, luckily for counsel, the court may not delegate the drafting of the order to counsel. The court must draft the order. And an order denying a new trial does not need to state the reasons for denying. On a motion to vacate, if it is granted, the court must enter a new judgment that supersedes the prior judgment. If it doesn't happen, the order granting the motion is void. Appeal rights. An order granting a new trial or a motion to vacate is directly appealable. An order denying a new trial or a motion to vacate is appealable from the originally entered judgment. So yes, I think that covers everything on a motion for a new trial, a motion to vacate. Really, if you come away with anything else on these post-trial motions, it is that timing is everything. You're going to make your arguments. You're going to try and convince that something went wrong during the trial, but you cannot get to that point if you have blown those deadlines. There is very little, if any, discretion the court has to allow any late filings or blowing any deadlines. All right, moving on. You've won, now what about costs? Costs are a fun issue in probate because we take a position that is different from the ordinary civil rule. The ordinary civil rule is that the prevailing party is entitled to recover costs as a matter of right. Now, the statute, CCP 1032, says the important qualifier is unless otherwise provided by statute. The probate code is otherwise provided by statute. Under the probate code, it is exactly the opposite. The court has discretion to award costs payable by any party or from an estate or trust. So therefore, if the judgment or statement of decision is silent, there is no entitlement to costs. So what do? You get towards the end of trial, you've submitted your case. Either you've made your closing argument or you've submitted your closing briefs. I highly recommend that in your closing briefs or in your closing argument, you request that the court make a costs order pursuant to Probate Code Section 1002. Now, this does not mean that the court is going to assign the amount of costs. 1002 is designed to allow the court to make an order determining entitlement to costs. The amount of costs is set separately, which we will talk about now. How do you claim costs? You use the mandatory Memorandum of Costs form on Judicial Council Form MC10 and the optional Memorandum of Costs worksheet form MC11. The deadline for filing your Memorandum of Costs is under Rule of Court 3.1700A1. It's 15 days after service of the Notice of Entry of Judgment pursuant to 664.5. See, we've got that number again, 664.5, or served by a party, or 180 days after the entry of judgment, whichever occurs first. Now, going back to the forms, even though it's optional, I really recommend using the Memorandum of Costs worksheet. It is super, super helpful. It's really, really helpful to the court in evaluating the entitlement to costs if any of them are challenged. So it's really important to, I think, to really set it out clearly. Now, the failure to timely file a Memorandum of Costs waives the entitlement to costs, although that time is not jurisdictional and relief may be had pursuant to CCP Section 473B. The Memorandum of Costs is verified under penalty of perjury, so no evidence is needed to support the claim until the claims are challenged by a motion. The claims must list each cost individually so that the parties in the court can evaluate the allowability of the claim. So you've got a memorandum of costs filed. How do you contest them? You file a motion to strike or tax. Oftentimes you see these motions filed in the alternative. You file a motion to strike or alternatively to tax certain costs. The motion is due 15 days after the service of the memorandum of costs. The old 1695 rule applies. It is to be served 16 court days prior to the hearing on the motion. Opposition is due 9 court days prior to the motion, prior to the hearing, and reply is due 5 court days prior to the hearing. So a little bit definitional. Motion to strike is a request that the court strike the entire memorandum. For example, the memorandum was not timely filed. That would be a perfectly reasonable ground to seek to strike an entire memorandum of costs. A motion to tax is asking the court to examine individual line items that for reduction or elimination. So you're actually taxing the costs. The motion to tax must refer to each item objected to by the same number and the same order as claimed in the memorandum. That seems kind of archaic, but it's really helpful for the court to have it in that order so we can evaluate it appropriately. Allowable costs. We're looking at CCP 1033.5A. So generally speaking, I'm not going to go through all of the types of costs that are allowable, but generally speaking, we're looking at filing fees, deposition fees, ordinary witness fees, service of process, and so on. There's a whole list of several types of costs under CCP 1033.5A that are presumably allowable. Want to make a couple of notes here. Number one, regarding expert witness fees. Expert witness fees are only allowable if the expert witness is ordered pursuant to Evidence Code Section 730, or if the expert witness, or if you have a statutory offer to compromise under CCP Section 998. For those of you that are not familiar with CCP Section 998, it is called a statutory offer of compromise. There are deadlines by which the offer can be made and is in a statutory format. However, if you make a settlement offer pursuant to Section 998 and it is either rejected or deemed rejected, then you take it to trial and you do better than what you offered in your 998 offer, then you would be entitled to recover your expert witness fees as well as other costs that were incurred after the service of the 998 offer. The opposite is true on if you end up losing or not doing as well than your 998 offer. I want to refer you to the Ellis Wendell Fuller case, the unpublished case that I cited to you in episode 4. That case, which is the case that I litigated and again is unpublished, the second half of that opinion discussed how CCP Section 998 works and whether or not the major issue is whether or not the settlement offer that we made was a reasonable offer under the circumstances such that we would be entitled to recover our expert witness fees pursuant to 998. I could very easily spend a half an hour talking about 998. It's a fantastic topic. So much so that I got to tell you, I don't see enough Section 998 offers made in trust and estates litigation, either when I was in private practice or when I got here to the court. So in terms of strategy, if you are involved in a case where you anticipate using expert witnesses, I strongly recommend that you discuss with your client the use of a reasonable statutory settlement offer pursuant to CCP Section 998. If you don't, then your client is very likely to be stuck with the expert witness fees that are incurred and that could have been recovered had you made the 998 offer. I strongly, if you're not familiar with 998, recommend that you study it. It is a very, very valuable tool. I have a question here from Mr. Paul Epstein. When the losing party does not file a motion to tax cost claim within a timely filed memorandum, what steps should the prevailing party take so that the costs claimed in the memorandum become part of the judgment previously issued? We're going to get to that. I'm so glad you asked that question. You beat me to it. We will get to that towards the end of the seminar. We're nearly there. So bear with me. We will definitely get to that. Another note regarding attorney's fees. Attorney's fees are allowed under CCP 1033.5A10, but only pursuant to contract, statute, or law. Generally speaking, unless you are operating in the unusual situation where your contract, if you're fighting over a contract, gives an actual formula for the amount of attorney's fees to be awarded to the prevailing party. If you are seeking attorney's fees as a cost under CCP 1033.5A1 or A10, you are required to file a separate attorney's fees motion. It does not go on the memorandum of costs. Now, the deadline to file that motion is the deadline to appeal the judgment. And that's under CCP 1702B1. It is, again, it's not something that the court can do pursuant to the memorandum of costs. It needs to be done pursuant to a separate, regularly noticed motion. Disallowed costs, CCP 1033.5B. Some examples: expert witness fees not ordered by the court under Evidence Code Section 730. Postage, telephone, photocopying, except for photocopying exhibits, transcripts not ordered by the court. Another example, under the Lattice case, legal research costs are not allowed to be recovered as costs under a memorandum of costs. There are lots and lots of authority that interprets CCP 1033.5. And I would strongly recommend, if you get into litigation over the allowability of costs, that you review a lot of that authority. Lattice is a good one. The Lattice versus California State Auto Association. It talks about a lot of individual types of costs that the court allowed or did not allow. That's good reading. Become familiar with the process. Then we have the third category of discretionary costs under 1033.5C4. Excuse me. So, general rule: items that are not mentioned as allowed or not allowed may be allowed or denied in the court's discretion. For example, mediation fees are expressly within the court's discretion under Berkeley Cement. So, oftentimes you don't talk about, when you're agreeing to mediate, who's going to pay the costs and whether or not they're going to be recoverable as part of a judgment. This takes care of that. It becomes discretionary with the court. Excuse me for 1 minute, please. Six seminars and my throat is finally becoming a little scratchy. There we go. Christy Raimondi, what is meant by research fees? Lexis, Westlaw, computer-aided research. Does this include searches for deeds and other property records? My opinion, no, because the Lattice decision talks about legal research in the context of investigation expenses in the preparation of trial, which is not allowed under CCP 1033.5B. So no, it does not include deed searches or property records. The general rules regarding all allowable costs. They must be, they are allowable if they're incurred, whether or not paid. Allowable costs must be reasonably necessary to the conduct of litigation and not merely convenient or beneficial to its preparation. That goes to that last question about deed searches. The courts construe that as being convenient or beneficial to the preparation of the trial. And of course, they must be reasonable in amount. Ruling on a motion to tax, items in the memorandum that appear to be proper are prima facie evidence that they were necessarily incurred. Remember what I said earlier, memorandum of costs is signed under penalty of perjury, usually by counsel. And so that becomes prima facie evidence that the cost is reasonably incurred. If the cost is reasonably permitted or expressly permitted by CCP 1033.5A, the burden is on the moving party to show that they are not properly chargeable or that they are unreasonable. Items in the memorandum that appear to be proper is, so in determining the motion, the court must first determine whether the statute expressly allows the item and whether it appears proper on its face. If the moving party is able to prove successfully, then the burden shifts to the party claiming the costs where the item is properly objected to. When the party offers no proof of costs beyond the memorandum of costs, the trial court has the discretion to disallow the cost. So when you get a motion to tax, if you're opposing a motion to tax, I strongly recommend that as to the items that are objected to, you provide to the court detailed proof of the expense, such as copies of invoices, so that the court can properly evaluate reasonableness and necessity to the case. Now, to answer that first question, what happens when you have your costs finalized? Either the motion, there's no motion filed, or the motion is denied, at least in part. So ordinarily, the court enters a nunc-pro-tunc judgment that includes the amounts of costs awarded, either after the time to move to strike or tax expires, or after the court rules on a motion. If the court doesn't do this on its own, without prompting from anybody, if you are the prevailing party, it is entirely appropriate to come in on an ex parte application for entry of a nunc-pro-tunc judgment, so that the amounts of the costs can be included in the judgment that you can then take to execute later. Again, this is a nunc-pro-tunc judgment. It does not affect any deadlines to appeal the underlying judgment, because costs awards are entitled to a direct appeal under CCP 904.1A2. So I know in our court, what we have done is at the conclusion of trial, we would see in a statement of decision, for example, the court make a determination about whether or not the prevailing party is entitled to costs, and then direct the filing of a memorandum of costs. And very similar language would be included in the judgment that is ultimately entered pursuant to the memorandum of costs. Then once you've gone through any litigation over the appropriateness of the costs, we would consider the motion, and then either the court would enter the order on a motion to tax and enter at the same time a nunc-pro-tunc judgment, but other courts might decide just to enter the order on the motion to tax, and then you might have to come in to request the entry of a nunc-pro-tunc judgment. So I hope that answers your question. It's a simple, effectively a re-entry of the judgment. So that is the end. Before I take questions, there are some people I want to thank for all of their help and support in putting this saga together. Certainly everyone at the Contra Costa County Bar Association, especially Catherine Korn, Oliver Bray, Sarah Marin, and Ann Wolf. Also, thanks to Judges George and Fenstermacher here in court who've been so patient with me and absolutely supportive of me in this little silly endeavor. Finally, and really last but not least, to all of you who are attending and for your incredibly supportive feedback. I hope that you found the saga to be even a little entertaining, but most importantly, informative. So now, having said that, while this is the end of this 6-episode saga, there could be many more topics out there that could be addressed in a seminar format. George Lucas waited 16 years between the original trilogy and the prequels trilogy, and then Disney waited 10 years between the prequels to the start of the final trilogy. I don't necessarily have to wait that long. If you like what I did and think that I can do a presentation on other similar topics in the future, please feel free to pitch them directly to me or through the Bar Association, and I would be happy to consider doing it. Whoops, hold on. That didn't work the way I wanted to. Man.
May the force be with you.
May the force be with you. May the force be with you. May the force be with you. May the force be with you.
May the force be with you.
May the force be with you. May the force be with you. May the force be with you. May the force be with you. May the force be with you. May the force be with you.
May the force be with us.
If there was a one-off episode from this series, what topics would it cover? Well, we did statements of decision on the last episode. So I mentioned 998 offers. Like I said, I could spend at least a half an hour talking about that, and so that would be a good one that one's pretty ripe. I like 998 offers. I think those are super helpful and can really help parties focus on settlement as opposed to really charging headfirst in litigation. Doug, I'm going to get to you in a second. If the court orders that discovery referees be paid exclusively by one party only as a form of sanction, is that cost that is directly appealable? No, although if I'm remembering this correctly, I don't have this right off the top of my head. But I believe that there is a threshold for discovery sanctions that the court allows a direct appeal. But I don't have that right off the top of my head. It would be like 904.1, somewhere in that area of the Code of Civil Procedure, but don't quote me on that. But generally speaking, discovery sanctions are not directly appealable in any way. So Doug, what Jedi do you most relate to, and what Sith do you most relate to? What Jedi do I? Probably Obi-Wan Kenobi, although let me change your question a little bit. The Jedi that was just, if spoiler alert here for those of you that watch Mandalorian, the Jedi that showed up in the last episode of Mandalorian last week, he was kind of awesome. I'd like to be him. Which Sith do I most relate to? I'm not nearly as whiny as Anakin Skywalker turning into Darth Vader. I don't do that. Probably, again, I would strive to be Darth Maul, because he's the best Sith. Anyway, do you think that you could resist the allure of the